Welcome to the Deep Dive. We're here again trying to make sense of important, sometimes dense material.
Right, distilling it down to what you need to know.
And we're continuing our journey through the MPEP, the Manual of Patent Examining Procedure.
Yep, think of this as helping you navigate the USPTO's rules.
Exactly. Useful if you're studying for the patent bar or just, want to understand how patent examination works.
And today we're focusing on a specific slice of pre-AIA law, MPEP Section 2135, which covers 35 U.S.C. 102B.
Okay, Pre-AIA 1022. So this relates to patent applications filed before the American Invents Act really changed things up.
Precisely. But it's still relevant in some contexts. It basically outlines how getting a patent in another country could prevent you from getting a U.S. patent.
Ah, so your foreign patent activities could come back to bite you, potentially. That sounds pretty important.
It definitely can be. The core idea is, under certain conditions, if you got a foreign patent on the same invention, you might be barred here in the U.S.
Okay. A bar based on foreign patenting. So what are those specific conditions? You said there are a specific trigger?
Yeah, there are 4 key criteria, and all 4 need to be met for this 102D rejection to stick.
All 4. Okay.
Let's break them down. The first one is all about timing specifically, the foreign filing date.
Okay.
The foreign application for that same invention must have been filed more than 12 months before the effective U.S. filing date.
More than 12 months. Okay, that sounds like the one-year bar we hear about elsewhere, but maybe a bit different.
It is related but distinct. The typical one-year grace period often relates to public disclosures or offers for sale. This 102 rule is specifically about the filing date of the foreign application. It's quite strict.
So it's not about whether the foreign application was published, just when it was filed.
Right. The filing date itself starts that clock. And that effective U.S. filing date can get complicated with things like provisional applications or continuations. But essentially, it's the date the U.S. application is considered filed for that invention.
Got it. File overseas. You've got basically a year to get your U.S. filing sorted for priority purposes. Otherwise, this could become an issue. What's criterion number 2?
Number 2 is about who filed it. The foreign application must have been filed by the same applicant as the U.S. application.
Same applicant?
Or, importantly, by their legal representatives or their assigns.
Assigns. So if I invent something, assign the rights to my company, and the company files the foreign patent, that counts.
Exactly. The company steps into your shoes, legally speaking, for this purpose. It's about the chain of ownership. MPP Section 300 discusses assignments, how they're recorded.
Yeah, it provides public notice.
Yeah. And under the old rules, 37 CFR 3.73b, the assignee actually had to formally prove they owned it to take action. So the USPTO looks at who really initiated that foreign filing.
Okay, so foreign filing more than a year before the U.S. filing by the same legal entity or its predecessor. Makes sense. What's the third element?
The third one is crucial. The foreign application must have actually matured into an enforceable foreign patent before the U.S. filing date.
Matured into a patent. So not just filed, not just allowed, but actually granted.
Granted and enforceable. That's the key word. It has to confer actual legal rights in that foreign country.
And enforceability is the test, not necessarily whether everyone could easily find and read it.
Precisely. The MPP gives the example of a German Gebrauchsmuster, like a utility model or petty patent. Even if it wasn't, say, published widely, if those enforceable rights were granted more than a year before you filed in the U.S.
That could trigger 102.
Correct. The courts have focused on the grant of enforceable rights. Inventor certificates are another example mentioned. Different forms of granted rights count.
Okay, enforceable rights granted abroad before the U.S. filing. That leads us to the 4th condition. It has to be the same invention, right?
Yes, the same invention.
Now, how is that determined? Patents can claim things differently, methods versus compositions, and laws vary.
That's a great question, and it's where it gets a bit more complex. The USPTO interprets same invention pretty broadly for 102.2.
Broadly how?
It's not just about whether the claims are identical, even if your U.S. claims are different. Maybe the foreign patent claimed a process and you're claiming the product in 102D rejection can still apply if the description, the specification in that foreign patent fully supports what you're claiming in the U.S.
Wow. So it's about the disclosure in the foreign patent, not just its claims matching the U.S. claims.
Exactly. The content of the foreign patent specification is key. There's a well-known case in Rakoff-Awala.
Okay.
In that case, a Spanish patent claiming a method was used to reject a later U.S. application claiming a composition. Why? Because the description of the method in the Spanish patent was detailed enough to fully disclose and enable the composition being claimed later in the U.S.
So the Spanish description essentially gave away the composition.
Right. It shows just how far the same invention concept can reach under 102 day. It's about the substance disclosed.
That really is a wide net. You might think you're claiming something distinct in the U.S., but if the underlying invention was described and patented abroad by you or your company more than a year earlier and enforceable before your U.S. filing, bang, 102 and 2D.
You've got it. That's the potential trap.
So this leads to thinking about things like continuation in part applications or CIPs. How do they fit in? You're adding new stuff.
Ah, yes, CIPs. They add another layer. Remember, a CIP adds new matter to an earlier application.
Right.
Well, if you file a foreign application, then later file a CIP in the U.S. that adds new information, you generally can't claim priority back to the foreign filing for that new information.
Okay, the new stuff gets the CIP filing date.
Exactly. So think about it. If your foreign patent, based on the original filing issues, and becomes enforceable more than 12 months before you file the CIP, you could potentially face a 102.2 rejection on the claims in the CIP that rely only on the original disclosure, the stuff that was in the foreign patent.
So adding new matter could inadvertently make your old matter vulnerable to 102 beg if the foreign patent issues in that window.
Potentially, yes. Because the effective filing date for the original subject matter might now be considered the CIP filing date if priority is somehow broken or wasn't properly maintained for all claims. MPEP 0200 talks about new matter issues. It's tricky.
Definitely sounds like something to watch out for when using CIPs after foreign filings.
Okay.
Okay, so how do examiners actually catch these things? Do they actively look for foreign patents?
Oh, yes. Examiners are trained to consider potential 102D issues. They'll search foreign patent databases, especially if there's a priority claim or other indication of foreign activity.
And they estimate issue times.
They might consider typical timelines for granting patents in certain countries, yeah. And if they suspect something, they can issue a requirement for information under 37 CFR 1.105. Basically asking the applicant directly about their foreign filings and patent status.
So they can actively investigate. Okay. Are there any other sort of tricky points or nuances with 102?
Well, one interesting situation is with allowed foreign applications. Sometimes an application might be allowed, maybe published for opposition by others.
Before it's officially granted.
Right. And if, during that opposition period, the applicant gets provisional enforcement rights, some ability to enforce the patent even before the final grant.
Ah, so even provisional enforceability might count.
It can be treated as equivalent to a patent for 102D purposes in some jurisdictions, if it provides actual enforceability and the other conditions are met. It comes back to that core idea of enforceable rights being granted.
Okay, that's subtle but important. Now, we've hit on timing and filing dates a lot. How does this all connect back to claiming foreign priority under Section 119?
It's directly connected. You know, under 35 U.S.C. 119, you can claim the benefit of your earlier foreign filing date in your U.S. application if you file the U.S. application within 12 months of the foreign one.
That's the standard priority claim.
Exactly. MPE 0200 covers the rules. But if you miss that 12-month deadline and you don't get a petition to restore priority granted,
You lose the benefit of the earlier date.
right. And then, if your foreign patent issues and becomes enforceable more than 12 months before your actual later U.S. filing date.
Point 102D could suddenly apply because you lost the connection to the earlier date.
Precisely. Failing to properly claim or maintain priority can inadvertently open the door to a 102D rejection that wouldn't have existed otherwise. It makes managing those priority deadlines absolutely critical.
So pre-AIA 102D is like a backstop if you got your foreign patent granted and enforceable based on a filing more than a year before your effective U.S. date for the same core invention and you didn't properly bridge the gap with priority, you could be barred.
That sums it up really well. It underscores why a coordinated international filing strategy and meticulous deadline management were, and sometimes still are, so vital.
This has been really clarifying. A deep dive into a specific but clearly impactful piece of pre-AIA patent law. So just to recap, the four horsemen of 102D foreign filing over a year before the U.S. date. Check. Same applicant or assigns. Check. Foreign patent granted and enforceable before U.S. filing. Check. And same invention, interpreted broadly based on the disclosure. Check.
You nailed it. Understanding those 4 points is key for anyone dealing with older applications or complex priority chains involving foreign filings.
It definitely avoids potential pitfalls.
Absolutely. It's fundamental knowledge for sound patent strategy, especially internationally.
Okay, so as we wrap up this look at MPEP Section 2135 and this pre-AIA rule, maybe something for you to think about is this. Given how interconnected global innovation is, how might these kinds of interactions between different national patent laws continue to shape patent strategies even beyond these specific pre-AIA rules? What's the next evolution in managing global patentability?
That's a great question. The landscape is always shifting. Careful planning remains paramount.
Indeed. And before we go, a special thanks to Mike Shepard, the creative director who organized and guided the development of this project.
Yes, thanks to Mike. And just the usual reminder, this summary was generated using AI tools. It's for educational info only. It's not legal advice.
Right. For the official word, always consult the official MPEP itself, or, talk to a qualified instructor or a registered patent practitioner.
Absolutely.
Thanks for joining us for this deep dive into Pre-AIA 35 U.S.C. 102J. We'll catch you next time as we continue exploring the MPEP.